Okay, hello and welcome everyone to today's webinar. My name's Carly Hanson from Community Legal Centres Queensland, and I'm facilitating today's session for you. It's our first webinar back for the year, and I'm really pleased that we have a fantastic session to kick things off. Today we've got Emma from QAI, and she'll be speaking on using the Human Rights Act to advocate for clients with a disability. Just before I go into that though, I'd just like to acknowledge the traditional owners of the land on which we are holding today's webinar. In Brisbane, they are the Turrbal and the Yagara peoples. I wish to pay respect to their elders, past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people throughout Queensland and Australia, I'd also like to pay my respects to the traditional owners of the land throughout the country and extend a warm welcome to any First Australians listening today. As I mentioned, I've got Emma Phillips from QAI, who will be speaking to us on the Human Rights Act, which commenced on the 1st of January this year. In particular, she'll be talking about how to advocate using the Act for clients with a disability. Today's webinar is being recorded, and I'll have the recording available for you to download later today or tomorrow morning. The PowerPoints have been sent out or uploaded to our website, so you can grab those if you like from there, and I'll also upload them to our system here on GoToWebinar for you to grab if you haven't already had a chance. We'll hold questions to the end of the session today, but I will let you know that there are two ways you can ask questions. So you can press the button that looks like a hand as you did earlier. We'll see those hands go up and we can unmute you if you have a microphone if you want to ask your question verbally. Alternatively, the easier way is to just type your question into the control panel on GoToWebinar, and I'll read your question out at the end for Emma to get to. Without further ado, I'll hand over to Emma now and come back to you at the end of the session. Thanks, Emma.
Thanks very much, Carly. I too would just like to acknowledge the traditional owners of the land on which we're meeting in Brisbane, the Turrbal and Yagara people. I'd like to specifically acknowledge First Australians with disability who have experienced some of the most significant and appalling human rights breaches throughout history, and express my sincere relief and gratitude that some of the basic rights of our First Australians are now protected under the Human Rights Act of 2019. Scrolling through, Carly. It's not wanting to move yet. There we go. Perfect. Thank you. Carly's gone through the housekeeping. Just a quick disclaimer before I begin. I'll just let that slide up there for a moment. And also just a keep safe note. Okay, so my name's Emma Phillips. I'm the Principal Solicitor at Queensland Advocacy Incorporated, or QAI. We're a disability advocacy organisation and a specialist community legal centre. We advocate for the rights and lives of the most vulnerable people with disability in Queensland. And we have traditionally always done this through systems advocacy. That's how we originated over 30 years ago, advocating for law, policy and practice reform to protect the rights of the most vulnerable people with disability. We now run 7 individual advocacy programs, which I'll talk about at the end briefly. These programs are both individual legal advocacy and non-legal advocacy. I'm really pleased to be speaking about this topic today. I was actively involved in the campaign that culminated in the Human Rights Act. From its inception, it was a long-term campaign that ultimately spanned approximately 5 years. And the reason for my involvement in this space was working for QAI in this as a disability advocacy organisation and specialist community legal centre. Every day, our centre assists very disempowered people who've experienced a breach of their fundamental human rights. It might be because they've been discriminated against, subject to involuntary treatment for mental illness, including ECT, been subjected to restrictive practices such as seclusion or chemical restraint, or removed from their family and community to be detained in a forensic detention service or authorised mental health service. They're just a few examples. And I know most of you on the line are also linked in because of your interest and experience advocating for very vulnerable people. So I'm really pleased to be speaking about this topic. I'm really pleased that we're here where we are now, post 1st of January 2020, where the Act is no longer an idea and then a promise, but is actually now part of the laws of Queensland. Just briefly, the aims of the webinar. I'm firstly going to look at how the new legislation can be used as an advocacy tool to protect and defend the rights of people with disability in Queensland. It's important for advocates and lawyers who specialise in disability advocacy and for CLC lawyers in general, given 1 in 5 Australians have a disability, and people with disability make up a significant portion of CLC clients. Hopefully, by the end of this session, you'll have a better understanding of the rights in the new legislation that are particularly relevant for people with disability and how to use the Human Rights Act as an advocacy tool in practice. And when I say that I'm speaking about people with disability, I'm including people with psychosocial disability or mental illness. So some of the examples I speak about will be in that context. So I'm going to address the changes introduced by the Human Rights Act with a focus on the implications for people with disability, the rights in the Act that are particularly relevant for people with disability. I'm going to give some practical tips and hints for using the Human Rights Act in advocacy for people with disability, and outline some strategic considerations that you might want to think about when you're using the new legislation. Now, I don't want to go into too much detail at all about the mechanics or the fundamentals of the Human Rights Act. I know there's been a session already done on that topic, and there's a lot of information out about that already. I was just going to very, very quickly cover a few of the basics so that we're all on the same page. As you well know, the obligations commenced from 1st of January this year. It's not retrospective legislation, so we're looking at actions that have happened from 1 January. There was a reasonably significant lead time for the introduction of this legislation, with the rebranding of the Anti-Discrimination Commission as the Queensland Human Rights Commission from the 1st of July last year, and the commencement of its educative functions around the new legislation from that date. The Human Rights Act protects human rights, which are the basic rights that belong to every person, regardless of their age, race, sex, social status, or other characteristic. And it protects the human rights of all people in Queensland. So everyone in Queensland is protected by it. You don't need to be a resident or have a particular citizenship or visa status. As you also probably already know, it binds public entities, both core and functional, with core public entities including ministers, government departments, public officials and servants, the Queensland Police, local governments, etc. Functional public entities are those entities that are discharging functions of a public nature when performing the functions for the state or a public entity. So just to confirm, complaints can only be made against a Queensland entity. Private businesses, private schools, etc. are not bound by the Act unless they have opted in, which is catered for in the legislation, nor is the federal government and its agencies, including Centrelink and Medicare. Of interest to many of you will be the fact that under Section 9 of the Act, NDIS service providers are specifically covered. However, the agency, the National Disability Insurance Agency, as a Commonwealth body, is not. The Act establishes a dialogue model with the 3 arms, the legislative, judicial and administrative. So all new and existing state legislation will be scrutinised for compliance with the Act. Courts and tribunals are required to interpret legislation in a way that's compatible with human rights, and public entities must consider and not limit a person's human rights in making decisions. There's an accessible complaints mechanism. We're the first Australian jurisdiction to have this. Now, we're the 3rd jurisdiction to have a dedicated piece of human rights legislation. The ACT has had one since 2004 and Victoria since 2006. Neither of those acts established a complaints mechanism, which we have in the Queensland Human Rights Commission. and which enables a person who feels that their human rights have been unlawfully limited to go directly to the Commission and make a complaint. And the Human Rights Act protects a range of human rights Australia has agreed to protect under international law. Just put up a table showing what human rights are protected. It's quite small, but you can see all of these in the index to the Act. Over the next 10 or so slides, I'm going to take you through some of the rights that I consider the most critical to know about when you're advocating for clients with a disability, and give you some examples of the way in which some of these rights have been used. Now, in covering these rights, which I've listed on the screen, I'm not meaning to imply that they are the only rights that are relevant, as all human rights apply to all people in Queensland. So all human rights are relevant to all people with disability. However, the rights I'll speak of now have particular significance for some particular issues and practices that disproportionately impact on the human rights of people with disability. And I do want to acknowledge that disability advocates already incorporate a strong focus on human rights as part of their organisational approach and work on behalf of clients. I know at QAI we have long referenced, since its finalisation and ratification, the Convention on the Rights of Persons with Disabilities, and I know many other organisations do likewise. I also think it's important to recognise the intersectional discrimination experienced by many people with disability, such that some rights breaches are more likely to be experienced by them. An example of this is if we consider the significant overrepresentation of Aboriginal people with disability within Queensland prisons, many of whom are far removed from their cultural networks and not having their fundamental disability support needs met. So as you can see, that engages a number of different human rights. Given the limited time we've got today, there's not, unfortunately, time to go into too much detail about each of the rights in the Human Rights Act, though I'll do my best. It is relevant to note that while these rights are new to Queensland, they are all underpinned by a well-established body of international law. And so if you're interested in further detail of these rights beyond what you already know and what we're covering today, I'd strongly encourage you to do some further reading, and there's some great resources available, including some really good new ones on the Queensland Human Rights Commission website, which I'll provide the details for at the end. And just briefly, under the Act, it's important to note that there are limitations placed on particular rights. Now, at international law, some rights are regarded as absolute. Under the Human Rights Act, no rights are absolute. That is, they're allowed to be limited, but only after careful consideration and only in a way that's necessary, justifiable and proportionate. However, while this is yet to be tested, it's anticipated that rights that are regarded in international jurisprudence as absolute rights, an example of this is the right to life. It's difficult to envisage a situation in which that right would be limited to any extent in its application in Queensland. And as you can see from this slide, Section 13 of the Human Rights Act is a relevant provision which allows for reasonable limits to be placed on human rights, which may be justified in a free and democratic society based on human dignity, equality and freedom. And when determining whether a limit's reasonable or justifiable, a number of factors can be considered, which is referred to as a proportionality test. And I've put those key considerations up on that slide for you to see. Now, my apologies, the next number of slides are very boring to look at, but I thought rather than just reading out the provision of the Act and then going into the interesting details about how it's being used, I've just put up a summary of each right so you can look at that, and I'll speak to some different ways that this right has or can potentially be used when you're advocating for a person with disability. So firstly, the right to recognition and equality before the law. So as you can see, that this establishes the right of every person without discrimination to be recognised as a person before the law, to enjoy their human rights, to be equal before the law and receive equal protection of the law, and to receive equal and effective protection against discrimination. I think this is a really important right for people with disability, and It's going to be the basis for protecting positive measures, such as the imposition of quotas for state government employers to employ a certain percentage of employees with disability, in my opinion. In the Victorian case, Parks Victoria, which was a case from 2011, it was found that limiting employment opportunities to Aboriginal people was a reasonable limitation on the right to equality of other groups, given the low percentage of Indigenous employment within that workforce. And I think there are strong analogies to be drawn here with the employment of people with disabilities within, for example, the Queensland Public Service. In another example of the way this right might be used, it comes from another Victorian case. A woman living with dual disability was ineligible for assistance in accessing services because neither of her disabilities, when considered separately, met the requirements of the relevant government departments. She sought to be moved into more appropriate living conditions as she'd been robbed and sexually assaulted in the special residential services in which she lived. The advocate for her wrote to the relevant government departments raising various issues of breach of the Charter, including recognition and equality before the law, the right that we're talking about at the moment, protection from inhuman and degrading treatment, the right to liberty and security of person. And the Charter supported the advocate to frame the woman's issues with regard to her rights and communicate these in a more effective way with departments. And as a result, she was appointed a caseworker, was moved into appropriate housing and receives 15 hours a week of one-to-one support. I should say at the outset, throughout this presentation, you'll hear me refer to a number of examples from Victoria, where obviously given the newness of the Act, we don't have any real case studies yet from Queensland. And Victoria's a good jurisdiction to look to because our Act is very closely modelled on the Victorian Charter of Human Rights and Responsibilities. Moving on to the next right, the right to life, that every person has the right to life and not to be arbitrarily deprived of life. Now, this right's modelled on Article 6 of the International Covenant on Civil and Political Rights, which we ratified in 1980. It's relevant to note that this right specifically exempts laws relating to termination of pregnancy or killing of an unborn child, so it's not relevant to abortion laws do not come within the Human Rights Act. Because the right to life is concerned with preventing the arbitrary deprivation of life, it can be relevant in situations such as the use of force by public authorities, the delivery of medical treatment, and the investigation of the conduct of public entities, particularly when a person dies while they're in the care of a public entity. This right imposes both positive and negative duties on public entities. The negative aspect of that is that public entities need to refrain from taking someone's life. The positive component is they also need to act to protect people from real and immediate risks to their life. I'll give you an example from the United Kingdom of how this right has been relied upon. A woman with a recurring depressive disorder had attempted suicide on several occasions. She was initially assessed by the hospital as being at high risk of deliberate self-harm and suicide. Following treatment, she was reassessed as moderate to high risk of self-harm. Her father was concerned about her condition and urged the hospital not to allow her to go home on leave or to discharge her too soon. However, she was discharged, and during the home leave, she took her own life. The Supreme Court held the hospital had a duty to take reasonable steps to protect her from the real and immediate risk of suicide, and the European Convention, which protects the right to life and was applicable in that case, had been breached. That's the case of Rabone and Pennine Care. Moving on to Section 17 of the Act, which establishes protection from torture and cruel, inhuman or degrading treatment. Now, this provides that a person must not be subjected to torture, treated or punished in a cruel, inhuman or degrading way, or subjected to experimentation or treatment without consent. This right's based, it also is sourced from the ICCPR. It's also found in Article 15 of the CRPD. And there's also a separate human rights treaty, the Convention Against Torture, and the optional protocol to that Convention Against Torture, which is very relevant at the moment because Australia only ratified that treaty just over a couple of years ago and is presently in the process of preparing for implementation of it. all of those different international legal instruments also recognise this fundamental human right. So it's great to see it recognised in a binding way in Queensland. Now, cruel, inhuman or degrading treatment or punishment is a broader concept than torture. It refers to treatment that's less severe than torture or doesn't meet the definition of torture but still involves abuse or humiliation. It doesn't necessarily have to be intentionally inflicted or cause physical pain. It can include acts that cause mental suffering, debases a person, causes fear, anguish, or a sense of inferiority. Some examples of this right might include the use of restrictive practices on people with disabilities, such as chemical or physical restraint, or seclusion on a person with disability, potentially forced sterilisation of a person with disability. The treatment of youth Dylan Voller at the Dondale Correctional Centre, which attracted significant media attention a few years back, is a good example of conduct that could engage this right. I'll take you through a few Victorian cases to give you an example of how this has been used in practice. In the case of Davies, a 2012 decision, a person with disability was living at a community residential unit and was dragged naked along a hallway. This caused the person to suffer bruising and grazing, as well as mental humiliation. And the Supreme Court of Victoria found the treatment of the resident constituted cruel, inhuman and degrading treatment. So we might expect that equivalent treatment by a public entity in Queensland could potentially give rise to a breach of that Section 17 of our Act. Another case example from Victoria involved a tenant of the Office of Housing who was expected to report maintenance items, yet was unable to do so because of his vision impairment, limited mobility and physical disability. The contractors who were engaged to complete the works requested that the tenant sign a worksheet confirming the work had been completed to the standard required by the Office of Housing. The man was, of course, unable to verify or do this due to his vision impairment. His advocate invoked the right of freedom from torture and cruel, inhuman and degrading treatment to successfully reverse the policy requiring persons with vision impairment to sign a works order. So that's another example of how that right's been effectively used. And in the Certain Children No. 1 case, which is quite a well-known case from Victoria from 2016, there were a few of these cases. The first one, and they were involving children at Barwon Prison. And in this case, what was at issue was the treatment of children which involved long periods of solitary confinement, uncertainty as to the length of lockdowns, fear, threats by staff, the use of control dogs, the use of handcuffs when moving children to outdoor areas, the noise of loud banging, screaming, failure to advise children of rights or of the centre's rules, lack of space and amenities, limited educational opportunities, the absence of family visits or religious visits. And the argument was run that this treatment collectively amounted to cruel, inhuman and degrading treatment. And I think it's clear how this kind of line of thinking could apply to the detention of young people or adults with disability in Queensland. Moving on to privacy and reputation, which is covered in Section 25 of the Act. Now, this is a broad right that's potentially really valuable to people with disability, and it often surprises people to learn that prior to the commencement of the Human Rights Act at the start of this month, there was actually no right to privacy in Queensland. People are often surprised of their vulnerability in that regard, but this right has been relied upon under human rights legislation in other jurisdictions, for example, to require provision of a shower curtain to enable a woman with disability in a group home to shower with privacy and dignity, to challenge the use of CCTV cameras in the bedroom of a couple with disability, and that was purportedly to monitor their parenting ability and ensure that their child was safe, but it was questioned as to why cameras in their bedroom were indeed necessary. I really like the potential power of this right because a lot of the outcomes that have been obtained in other jurisdictions and are obtainable by reference to this right are really very simple, basic things that aren't costly. A shower curtain, for example, but they're things that are extremely significant and touch upon the fundamental human rights of a person. Another example that shows the non-costly and important nature of this right is that it's being used to protect a man with physical disability living in shared supported accommodation who was objecting to his mail being opened by his support workers on the basis he was capable of opening his own mail, and he wanted his right to privacy respected. The unit had a policy of opening mail for residents, which was purportedly to ensure accounts needing payment could be taken care of, and that policy was applied indiscriminately. The man's advocate successfully relied on the Victorian Charter, in particular this right, or its mirror in the Charter of Victoria, to effect a forced change of policy pursuant to which the man and other tenants as well in his position were able to open their own mail. So you can see they're really quite simple, basic outcomes that people are wanting, relying on this and other rights. But in the absence of having that right, it's been very difficult to enforce and to compel particular decision makers to do what would seem to be a common sense and humane response. So it's great to see that right in the Human Rights Act. The next right I'm going to cover is the protection of families and children. You can see that right, it's up there. Families are entitled to be protected by society and the state. Every child has the right without discrimination to the level of protection they require in their best interests, and the right to a name and to be registered. So this right has been relied upon to help keep families intact with appropriate support and prevent the forced removal of children from parents with disabilities. A Victorian woman with cerebral palsy was at risk of having her child taken from her by Child Protection because of concerns about her ability to care for her daughter. The woman relied on the right to protection of families and children, as well as the right to equality before the law, and was then given the opportunity to demonstrate her ability to care for her daughter, with the result that her daughter remained in her care. Now, removal of children from parents with disability has been a distressingly common situation in Queensland. I remember quite vividly during the Human Rights campaign that there was a case very similar to the one I've just described, and the family in Queensland didn't have the protection of a Human Rights Act to rely upon, and ultimately that family was fragmented and the child was taken into state care. At about the same time in Victoria, a very similar case again resulted in a much more favourable outcome, which is akin to the one I've just described to you, relying on the human rights in the Victorian Charter. So having human rights protection really does make a real difference to the outcome of matters such as these. Section 29 establishes the right to liberty and security of person. It protects against the unlawful or arbitrary deprivation of liberty. It establishes an entitlement to certain minimum rights for persons arrested or detained, including the right to be brought to a trial without unreasonable delay. I think this right also potentially is going to be really powerful given the significant issues we have and continue to face in Queensland insofar as the detention of people with disability, both those processed through the mainstream criminal justice system and those diverted from it, and the particular concerns around the indefinite detention of persons with intellectual and cognitive impairment. Yet another example from Victoria where the right's been raised in the context of an involuntary treatment order, which was ultimately found not to be a breach of the right to liberty, but gives a good illustration of how it was argued. Evidence indicated the patient would be a risk to himself and others if released. His behaviour only stabilised in a structured high-security psychiatric treatment facility to which he was confined, and it was held that the order was necessary to fulfil his treatment needs and was therefore in his interests and a reasonable limitation of his right to liberty and security of person. But potentially with the different factual scenario, the outcome could have been different. Risk to self and community is going to remain relevant, so it is going to depend on the circumstances of the matter, but you can see we now have additional relevant considerations that are drawn from the human rights legislation. The right to liberty has been found in the UK under their Human Rights Act to support the right to a timely hearing. There was a case, KB and others, where there were patients detained under the Mental Health Act of that jurisdiction, and each of them applied to the Mental Health Review Tribunal for a review of their detention. In each case, the hearing arranged by the tribunal was repeatedly adjourned, leading to delays of up to 22 weeks. And the applicants argued that on the specific facts of their cases, the delays they suffered could not be justified, and the court found that the delays were in fact not justified and that they'd not received a speedy hearing as required by the right to liberty and security under the Human Rights Act. Section 30 establishes the right to humane treatment when deprived of liberty, and I think this right is going to be particularly relevant for persons with disabilities subject to practices such as lengthy solitary confinement or denied adequate supports and services within prisons, correctional centres. One example of the successful utilisation of this right is from Victoria, where a physically disabled person in a corrections facility was frequently deprived of his necessary aids while being moved from one part of the correctional facility to another, which would result in him being without his aids for weeks at a time and consequently suffering a great deal of pain. The advocate used the Charter, specifically invoking the right to humane treatment when deprived of liberty, and as a consequence, the aids were returned to him, and it was assured that they would remain with him for the period of his sentence. Now, there are significant problems with prisons in Queensland for people with disability, particularly insofar as meeting the basic disability support needs of inmates. So I think the Human Rights Act provides us with a more solid basis to challenge this. The right to education and the right to health services, which are two further rights I'm going to discuss, they both fall in the category of economic, social and cultural rights. The rights I've covered so far are civil and political rights. Now, I could speak at great length about this right to education. It's a really important right. The inclusion of this right attracted a lot of attention due to, at least in part, to some of the problems that we have been experiencing in Queensland with schools arguably not delivering on the promise of inclusive education for all students. There was also a lot of contention around the wording of this right when it was included in the bill that became the Human Rights Act. I don't want to labour over it too much because in the next webinar in the series, is going to specifically address this right. So I will just, I wanted to allay fears that in response to some of the concerns around the drafting of this right, it was clarified that the human rights included in the bill, which is now the Human Rights Act, are in addition to other rights and freedoms, and therefore the provisions in the Anti-Discrimination Act continue to operate to protect vulnerable Queensland students from unfair discrimination. So that was one of the concerns, that the bar was potentially not quite as high as what had been established under the discrimination legislation, and that the reference in subsection 1, which you can see that there's the right to access primary and secondary education appropriate to their needs, could actually be used to further entrench separation in education rather than inclusive education, and was contrary to the laws that we indeed have at the moment, to the provisions of the Anti-Discrimination Act and to inclusive education policies. So we think that isn't going to be the case, and strongly encourage advocates to demand that that indeed isn't the case, and that rather this is establishing a positive right that gives extra protection to all Queensland students. I'll tell you about a matter that we were involved in a few years ago. We assisted a student who was 8 years old at the time and attending a state primary school in Queensland. On numerous occasions, he was put into a withdrawal room, as they called it. He called it the dark room. This child wasn't provided with any form of educational support during the lengthy periods in which he was contained in the withdrawal room, and he suffered some significant adverse effects from this, including experiencing feelings of fear while left alone in the room, stigma, and he was denied ordinary educational opportunities to learn and to engage with his peers. Now, the family rightfully considered this behaviour management, as the school called it, could well constitute psychological abuse, deprivation of liberty, torture, cruel, inhuman and degrading treatment, physical abuse, assault. That's a long list, all of which were well grounded, in my opinion. The child's human rights were also breached by the failure of the school to provide quality, inclusive education and to make reasonable accommodation for his support requirements. Without any kind of legal protection or remedy, the family considered their best option was to move the child to another school which had a more inclusive and supported learning environment, and happily the student did go on to thrive there. However, I don't need to explain the multiple human rights breaches this treatment entailed and the effect on the child and his family. The fact that the school shouldn't have had to relocate the child, and how there are many other children that have been in this child's situation that haven't had the fortune, and I use that in a very qualified sense given the experience the child had, but to have another local state school nearby that the student was able to attend that did have a very different culture. Now, in Victoria at around the same time, and the Charter of Human Rights and Responsibilities, which has been in operation for nearly 15 years now, was in place at the time. There was a boy with a learning disability who was threatened with expulsion by his school due to his behavioural issues. That child's advocate was able to outline to both the school itself and to the Department of Education the relevant human rights which belonged to that student, and as a result of the communication, that student was provided with the supports he needed, which reduced his behavioural issues and facilitated his continuing education at the school. And I'm really encouraged by that, because our Human Rights Act is stronger than the Victorian Charter. It specifically includes this right to education, which the Victorian Charter does not. And so I think we can certainly expect and demand those type of outcomes that have been obtained in that context, in that jurisdiction. The right to health services, I'm also really excited by the inclusion of this right. It's a really important right. We're really pleased to see it in the legislation. I think particularly when coupled with some of the other rights, such as the cultural rights of Aboriginal and Torres Strait Islander people, this right has the potential to address some significant human rights breaches in a way that we haven't been able to previously. Within the community, sadly, too often we see situations where the health needs of people with disability are not treated with the same urgency as the health needs of people without disability. And I think this right can be used to challenge that treatment or lack thereof. In disability-specific institutions, forensic disability services, mental health services, the rights of people with disability to access health services is often neglected. Even ironically, I know I mentioned health services, but I'm thinking here of like authorised mental health services, and the right to access more general health care is often neglected. Now, the inclusion of this right to health services will provide a lawful basis upon which to challenge refusal or omissions to act in this regard. I've just got 4 final rights to cover, and I'll just do so quite briefly without seeking to diminish their importance. Section 18, a person must not be held in slavery or servitude. A person must not be made to perform forced or compulsory labour. Now, this right, while I think it remains to be explored, can potentially be used to challenge the use of wage assessment tools or the practice of housing employees with disability in Australian disability enterprises, also known as sheltered workshops, subject to certain conditions. The right in section 19 to freedom of movement. Now, to give you an example of how this right might be used to advocate for the rights of a person with disability in Victoria, it's been used for a patient in a supported accommodation unit who was not provided with appropriate services which he was entitled to. In particular, he was unable to leave the unit to integrate with the community. And invoking the equivalent of that right in Victoria, the advocate was able to successfully ensure services were provided that enabled his integration into the community. Orders under the Mental Health Act of Queensland, or court orders directing where people on bail or under supervision may live, could also engage this right. This, of course, won't be an unfettered right, and we can see examples of what have been considered to be reasonable restrictions on freedom of movement in case law from Victoria and overseas in matters including lawful detention, guardianship orders, and involuntary treatment orders. So it's a relevant right to note, but it's certainly not going to necessarily create a particular outcome. A person with mild intellectual disability was subject to an order which only allowed him to leave his psychiatric facility if accompanied by staff members. And it was found, this is a 2009 decision from Victoria, that the only less restrictive option, which was voluntary treatment, was not appropriate given his history of violent outbursts, and so the order was upheld. So that's an example of where that right to freedom of movement was relied upon but not found to justify the order sought. A supervision order was placed on a convicted person who'd already served his term of imprisonment, and this was found to be a reasonable limitation on his freedom of movement because of the risk of him committing another offence in Secretary Department of Justice and AB, a 2009 case. So in both of these Victorian cases I've just referred to, you can see the risk to safety is weighed very heavily. We're yet to see how this is going to play out in Queensland. Section 23, taking part in public life. I'll give you an example again from Victoria where this right was relied upon, the case of Slattery and Manningham City Council, where Mr Slattery was a resident and ratepayer of the city of Manningham who'd lived in the city for many years. He had bipolar disorder, ADHD and post-traumatic stress disorder, as well as an acquired brain injury and a hearing impairment. He made thousands of complaints to Manningham City Council, and eventually the City Council decided to prohibit him from attending any building that council owned, occupied or managed in response to this. So this meant essentially he was not able to use public toilets, public swimming pools, public libraries, etc. He argued, and was successful in doing so, that the council's actions breached the Victorian Human Rights Charter as it unlawfully engaged his right to participate in public life. And finally, property rights, which establishes the right of every person to own property and not be arbitrarily deprived of their property. A man suffering from physical disabilities and limited mobility continued to live in his family home after his mother had been admitted to an elderly care unit and placed under a financial administration order by VCAT, which is the Victorian equivalent of QCAT. In order to prevent the home being sold, the advocate raised the right to property under the Charter, and in consideration of this human right, an agreement was reached whereby the man could continue living in the house as a tenant paying rent. So that's by no means an exhaustive list of the relevant rights or the ways in which they can be used. It's really just the tip of the iceberg. But I hope that gives some ideas of different ways in which those rights have been used and can potentially be used to address some really serious human rights violations that have been and are being experienced by people with disability in Queensland. I just wanted to speak briefly about the importance of building a human rights culture. Human rights legislation has had a really vital role to play in developing a human rights culture in any society. And on this slide here, I've summarised a few key ways that this is done by creating concrete rights that can be raised in decision-making deliberations, providing a source of binding obligation on decision makers that can lead to early resolution of an issue before it escalates to litigation, allowing for litigation when an adjudicated outcome is needed, and requiring training and education in the public sector. Our Human Rights Act contains provisions that guide decision makers when they make any decisions affecting someone else's rights. Decision makers are obliged to identify and give proper consideration to human rights and must make decisions as far as possible in a way that's compatible with human rights. These provisions hopefully will lead to overall better and clearer decision-making processes about all sorts of issues. And advocates have a really important role to play in this space in raising human rights issues, reminding decision makers of their obligations under the new legislation, helping them to understand what an outcome that respects and protects a person's human rights actually looks like. In Victoria, their Human Rights Charter has been used as a basis for acquiring different departments, including the Department of Education, for example, to develop reference guides and training for staff and human rights education for students, which is really important in fostering the development of a human rights culture in which people understand and are aware of what their human rights are. And this is really powerful in my mind, because we do know that rights are best protected not through litigation with all its attendant costs and stresses, but by the establishment of a strong human rights culture within the government. The powers of the Queensland Human Rights Commission to make preliminary inquiries under Section 68 and 78 of the Human Rights Act are strong. There aren't equivalent powers under the Anti-Discrimination Act, so we're waiting to see the impact of the exercise of these powers, but I think it's really quite exciting to watch that space. So in a nutshell, I think our Human Rights Act is not perfect. We've acknowledged that from the outset. It's not going to be a panacea, particularly for people with disability in Queensland, but it does create important rights, important opportunities we've never had before. It doesn't create rights, but it creates these rights in an enforceable way in Queensland. Just a few tips for human rights advocacy. A key tip is to raise the Human Rights Act at the earliest opportunity. So if you have a client that you're advocating for and you have the opportunity to write to a relevant public entity like a state government department, to go to a stakeholder meeting with that client and to make sure that decision maker is aware of what your client's human right is and of their obligations in respect to it, the earlier the better to do that. So if you're advocating for a student with disability in a Queensland state school, this might include raising the Human Rights Act in a meeting with the school principal or in meetings with the Department of Education. What we've found in learnings from Victoria and the ACT is that the real value of this legislation has been in ensuring that human rights considerations are heeded in decision-making contexts in which they would otherwise not be. In discussions and negotiations to protect and enforce human rights, it's important these rights are considered not only as negative rights, such as to protect a person from harm, although in the context of many of the basic human rights of people with disability and some of the practices to which they're subjected to, such as the use of restrictive practices, for one example, indefinite detention for another, this is going to obviously be critically important. But it's also important to raise them as positive rights, such as the right to the supports that a person might need to access the community or to enjoy a properly inclusive education. So understanding both those negative and positive ways that the Act can be spoken about and relied upon, I think, is really important. And I think taking that approach is consistent with the rights-based approach taken by the Convention on the Rights of Persons with Disabilities, which demands protection from the most flagrant types of rights abuses, such as freedom from discrimination, torture, cruel, inhuman or degrading treatment or punishment, exploitation, violence, abuse, etc. And it also establishes positive rights, such as the right to privacy, the right to freedom of movement, access to justice, and to inclusive health, housing, education and employment. Some strategic considerations. I think it's important to use the Human Rights Act wisely without in any way wanting to dampen anyone's enthusiasm or optimism about it. It is just an ordinary act of parliament. It's not constitutionally entrenched, so it can be amended or repealed just like any other piece of legislation. We're really very interested in developing a strong collection of stories to help protect the Human Rights Act should it ever come under challenge, so that we can show its use and its value. Please do rely on it to try to compel decision makers to consider human rights in their decision making and in their practices and in their application of policies, to challenge power imbalances that almost invariably exist when you're advocating for a person, particularly a vulnerable person, against a government entity, and use it to challenge what can be the unthinking application of bad policy or any policy, just without tailoring it to consideration of a person's circumstances. But my opinion, and you may not share this, is that we do need to think carefully about which cases we actually litigate. In Victoria, some of the early cases are still authoritative in shaping the way in which the Victorian Charter of Human Rights and Responsibilities has been interpreted. And I've spoken about the importance of building a human rights culture in Queensland. and how the Human Rights Act gives us an opportunity to start to develop a human rights culture in Queensland, or to further develop it, depending on your position in that regard. And we can use and rely on the fact that we have our Human Rights Act to require different departments to develop reference guides, training for staff to foster the development of a human rights culture. Just put this slide up there. I think it's quite, represents quite well the reality of our sector, which is limited resources and high demand. I mean, we all know the realities, the joys and challenges of working in this sector. I guess for me, it's about really making the most of what we have, knowing how to use what we have. There is very limited funding for work under this Act, for advocacy work, but we do need to use our knowledge to work out how we can use the Human Rights Act in matters that we would be advocating on anyway, in how to use it as an extra tool in our toolbox for our clients. So in summary, what I hope that you'll take away from this webinar is appreciation that it is potentially a powerful advocacy tool to protect the rights of people with disability, that there are a number of new rights that can be used to target some of the human rights breaches that people with disability in Queensland do experience, and that we should use the Act wisely in a positive and proactive way as the foundation for making rights-based arguments on behalf of our clients. I've put QAI's website there and our phone number, and I've also put the website of the Human Rights Commission. As I mentioned earlier, they've got some terrific resources that you can access online, and are very open to being contacted for further information. They're the collection of our individual advocacy services. And so although we do have a human rights legal service, and much of the focus of thinking around projecting and planning for that service has been around how we're going to use the Act for clients of that service, I thought I'd just mention that we are actively also considering ways in which we can use the Human Rights Act in our other services. And so I'm sure you're all doing the same. We're just putting it up there to show that the range of our services, all of which we'll be looking at how the relevance of the Human Rights Act. Thank you.
Thanks so much, Emma. That was really comprehensive and some excellent case examples there. So thank you again. I'll just remind everyone that we do have time for questions, and you can ask your question by typing that into the question box on the GoToWebinar control panel, or if you have a microphone and you'd like to verbally ask your question, you can do that by putting your hand up, and I'll be able to unmute you from this end if you'd like. So just while those questions are coming through, and please do take this opportunity to pose any questions you may have to Emma while she's here. I've got a captive audience, so and she's happy to chat to you about these things. But I just will also let you know that we do have a webinar next week, as Emma mentioned, on the right to education specifically. So we're really fortunate to have Bridget Burton, who's human rights extraordinaire from Caxton Legal Centre, presenting for us next Friday. You may have seen an email come out that mentioned Friday the 6th. Of course, that is not the right date. It is Friday the 7th. My apologies if you saw that one come through. But yeah, please do register for that one when you see that come through your inboxes. So I've got a couple of questions that are coming through. Do you want to do this one?
Sure, yeah. That's probably one.
Okay, so yeah, just a couple of quick questions. So Murray's just asked whether there'll be a list of the cases that you referred to in today's webinar posted on the QAI website, and possibly on the CLCQ website as well. Emma?
Sure. I haven't actually prepared we haven't at QAI published a list of those cases. In terms of which I certainly can make that list available to you, Carly. But they are only touching on a small number of the examples of cases out there. I personally, in my work, find the Human Rights Law Centre's website a really, really helpful resource. They've got a very user-friendly database of cases that's not exclusive to Victoria, but has been developed over a number of years, and is very easy to search in terms of keywords, rights, case names. That's on their website, hrlc.org.au, I believe, but yeah, easily Googleable. The Queensland Human Rights Commission also has done, my memory is they did a series of Facebook posts for Human Rights Month where they were going through each of the rights in turn and giving some examples. And so there's some reference to some good cases in there, which obviously aren't disability specific, but more generally applicable. On our website at the moment, we do have it's housing the resources we developed for the Human Rights Act campaign. And one of those resources is a fact sheet as to how, at that point, it was hopeful that we would get the Act and how the rights would be relevant to people with disability. So I encourage you to access that. We are developing a more comprehensive resource that we're hoping to publish as soon as time permits.
Thanks, Murray. Gay's also sent through a question. I'm not sure whether you're in a position to speak to this, Emma, but it's just really around her concerns about the equity of pay for people with disability and whether that might be able to be addressed under the Human Rights Act.
Yeah, thank you, Gay. That's a good question. It is one that I've been contemplating, and I haven't. I do need to give this some further thought as to how this is going to potentially be able to be used. One of the long-term systemic advocacy priorities for our work at QAI has been around the use of the BSWAT, which I'm sure is familiar to many listeners, but the Business Services Wage Assessment Tool, which has been phased out and replaced by the SWS. But ultimately, these tools do justify the use of a productivity-based means of assessing what a worker with disability should be paid, which is often well below what is prescribed by the applicable award, or industrial agreement. And QAI has long advocated for the position and held the view that that is in breach of their fundamental rights, including that the right to not be discriminated against, because in my mind that is very clear discrimination. I also have been interested in Section 18 in that space and how that might be applicable, because I think it would be possible, and I haven't given this too much thought yet, but to argue that the payment of well below award wages in certain circumstances subject to the facts of a particular matter may actually constitute slavery or servitude, as well as where a person's working and being exploited in a sheltered workshop or Australian disability enterprise.
So I think that might cover all of the questions that we've got through today. So and got lots of thank yous coming through, Emma.
Thank you.
Hopefully everything was covered, and certainly where there might be some additional resources that are made available either by QAI or others on this right or on this group of people, we will certainly publish those on our website and direct you to the QAI website if that's appropriate as well.
Sure.
But please do check out those other resources and organisations who may be able to sort of provide some scaffolding around that too. So thank you everyone for coming along and listening today. It was fabulous, and thank you so much, Emma, for presenting and taking time out of your very busy day to talk to us about people's rights with disability.
Pleasure. Thank you. Thank you, everyone.
Thanks.